Justice Kennedy has the opinion of the court in Case 16-111, Masterpiece Cakeshop versus the Colorado Civil Rights Commission.
In the year 2012, a same-sex couple visited Masterpiece Cakeshop, a bakery in Lakewood, Colorado. They wanted to make inquiries about ordering a cake for their wedding reception. The shop's owner told the couple that he would not create a cake for their wedding because of his religious opposition to same-sex marriage. The couple felt that the baker's refusal constituted discrimination on the basis of sexual orientation in violation of Colorado state law. And the relevant Colorado state law is the Colorado Anti-Discrimination Act. So the couple filed a charge to that effect with the Colorado Civil Rights Commission. The commission determined that the shop's actions violated the act, and it ruled in the couple's favor. The Colorado state courts affirmed the commission's decision, and this court granted certiorari. The case presents difficult questions as to the proper reconciliation of at least two principles. The first is the authority of the state to protect the rights and dignity of gay persons who face discrimination when they seek goods or services. It's unexceptional that Colorado law can protect gay persons just as it can protect other classes of individuals. It can protect them in acquiring whatever products and services they choose on the same terms and conditions as are offered to other members of the public. Our society has come to the recognition that gay persons and gay couples cannot be treated as social outcasts or as inferior in dignity and worth. The laws and the Constitution can, and in some instances must, protect them in the exercise of their civil rights. The second principle is the right of all persons to exercise fundamental freedoms under the First Amendment. The freedoms asserted in this case are both the freedom of speech and the free exercise of religion. The baker argues that Colorado law would force him to use his artistic skills to make an expressive statement inconsistent with his deepest religious beliefs, a wedding endorsement in his own voice and of his own creation. The court's precedents make clear that the baker, in his capacity as the owner of a business serving the public, might have his right to the free exercise of religion limited by generally applicable laws. And while religious and philosophical objections to gay marriage are protected by the First Amendment, it is a general rule that such objections do not allow business owners or other actors in the economy and in society to deny protected persons equal access to goods and services under a neutral and generally applicable public accommodations law. Yet, in this sensitive context, the baker likely found it difficult to find a line where the customer's rights to goods and services became a demand for him to exercise the right of his own personal expression. At the time of the events in question, state law afforded storekeepers some latitude to decline to create specific messages the storekeeper considered offensive, and the state of Colorado itself did not recognize the validity of gay marriages performed in its own state at the time these events occurred. Whatever one may think of the events that gave rise to this case, the baker was entitled to a neutral decision maker who would give full and fair consideration to his religious objection. The delicate question of when the free exercise of religion must yield to an otherwise valid exercise of state power needed to be determined in an adjudication in which religious hostility on the part of the state itself would not be a factor in the balance the state sought to reach. That requirement was not met here. When the Colorado Civil Rights Commission considered the case, it did not do so with the religious neutrality that the Constitution requires. During the public meetings at which the Commission deliberated about the case, commissioners made a series of disparaging remarks about the baker's religion. These comments were not disavowed by the Commission or by the state at any point in the proceedings that led to the affirmance of the order. In addition, the Commission's consideration of this case was quite different from its consideration of cases of other bakers who declined to create cakes requested by customers because those bakers objected to the message the requested cake would convey. The expressions of hostility toward religion and the disparate treatment this case received were inconsistent with the official neutrality that the Free Exercise Clause requires of all government officials and institutions. Given all these considerations, it is proper to hold that whatever the outcome of some future controversy involving facts similar to these, the Commission's actions here violated the Free Exercise Clause, and its order must be set aside. The adjudication in this case concerned a context that may well be different going forward. The outcome of cases like this in other circumstances must await further elaboration in the courts. This will be in the context of recognizing that these disputes must be resolved with tolerance, without undue respect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in the open market. Justice Kagan has filed a concurring opinion in which Justice Breyer has joined. Justice Gorsuch has filed a concurring opinion in which Justice Alito has joined. Justice Thomas has filed an opinion concurring in part and concurring in the judgment in which Justice Gorsuch has joined. Justice Ginsburg has filed a dissenting opinion in which Justice Sotomayer has joined.